Good evening, everybody. I'm Betsy Fischer Martin, the Executive Director of the Women in Politics Institute at American University. And welcome to our virtual series, Women on Wednesdays. We're glad that you could join us. To those of you new to our events, WPI is a nonprofit and nonpartisan institute in AU School of Public Affairs that aims to close the gender gap in political leadership. And we offer academic and practical campaign training, and we facilitate research and discussions like this on women in politics. So tonight, we want to take a look back, all the way back 100 years to the era right after the ratification and passage of the 19th Amendment, because understandably, the fight for women's equality did not stop with the success of the suffrage movement. There was more to do, and that's what our discussion will center on this evening with Dr. Rebecca Wolf, who has DeWolf, sorry.
That's okay.
Has written an amazing new book. It's entitled Gendered Citizenship, The Original Conflict Over the Equal Rights Amendment, 1920 to 1963. And Dr. DeWolf is a historian who earned her Ph.D. right here at American University. And we are proud that she is also a WPI course instructor this semester, teaching a class on this very subject. And I'm sure we have a few of her students joining us this evening. I want to let everybody know before we start that we're going to save plenty of time for your questions. At the bottom of the screen, you will see a Ask the Question button. So please don't be shy. Feel free to type your question in there. And you can also upvote other people's questions that you may be interested in. And if you miss any of the discussion tonight and want to share it with friends, the replay will be available at the same link that you used to register. So Rebecca, welcome. Thanks for being here.
Very excited to be here. Thank you for having me.
Of course. So we have a lot to cover. I mean, this book is amazing. First of all, I will just say that what I really enjoyed about the book is that it's sort of a twofer. You have an academic component, obviously, with lots of footnotes and references and sources, but it also reads really, really well, and it's just super interesting to read. So it's I think for two audiences. So anyway, I would recommend anybody who's interested in the subject to grab a copy of Rebecca's book. You can see the green link on the screen, and there's even a special discount code in the chat if you want to buy it. But let me start, Rebecca, with two kind of scene setters. The first being set the scene for how you as a student of history really decided to study this particular time period in the history of the ERA. Because I will note that if you're with us tonight and you're thinking, wasn't the fight over the ERA really in the 70s with Phyllis Schlafly, Gloria Steinem? You're probably not alone if you think that, right? That earlier era is really not written about nearly to the extent that the later era, of course, and the battle has been. So tell us why this moment in history is particularly important.
So that's a really great question. And I'm going to just start off of how I became interested in the ERA to give a little bit of foundation. So just as some background, this book is based off of my Ph.D. Dissertation research. Mm-hmm. And I first came to the ERA my first year of my Ph.D. program, so 2008, 2009. And I'll just say as an aside, things with the ERA in 2008, 2009 were much different back then than they are today. Mm-hmm. There's a lot more support for the ERA today and more knowledge about it. But at this earlier time, there was really just a general lack of knowledge about the ERA. So I came to the topic because my PhD advisor at the time, Alan Lickman, asked me to give a lecture on the ERA for a class that I was his teaching assistant for. And so I got into the research at that point. I was like, okay, this is an interesting topic. But what really got me going is after I gave the lecture, I opened it up to the class for discussion. And some of the students said something along the lines of they had no idea that the ERA wasn't ratified. So that was interesting. Mm-hmm. But a considerable amount of the students said something along the lines of, well, yeah, we recognize that there's still persistent sex discrimination against women, but we don't see the ERA as a solution to that problem. So that just set off a lightning bolt of curiosity for me. why hadn't the recognition of persistent sex discrimination not caused more of a robust push for the ERA? So I really want to solve what seems like a disconnect between realizing that there's still ongoing problems in society that are holding women back, but not thinking that the ERA is a solution to that problem. So around this time, I should also say that I had to read a book for a graduate course called Susan Douglas's Where the Girls Are. And it's a great book on the history of women's media, or the history of media's portrayal of women. And she has this great and insightful discussion of the ERA in the 1970s as representing the classic catfight imagery that we so often see with how women are portrayed in the media. So this catfight imagery it depicts women as constantly fighting with one another, overly emotional, they just can't get along. And the implicit suggestion from this imagery is that this is why women aren't fit for leadership positions. And so that strongly impacted how I approached the ERA. I really wanted to get away from the catfight imagery. I wanted to see if and how the ERA struggle may have represented more than a struggle between two groups of women. And so at first I was just interested in all parts of the ERA. So I was writing like all my graduate papers on it and just being quite obsessive about it. But I became more drawn to the earliest years of the ERA conflict because, as you mentioned, very little is written about it. And it just seems like a mysterious part of the ERA's history because so many of the dividing lines that you see in other areas of US history just don't play out the same way in the original ERA conflict. So what I mean by that is you have conservative and liberals on both sides of the issue. You have men and women on both sides of the issue, feminists on both sides of the issue. So it's just not an easy conflict to figure out what the dividing lines were because you're seeing overlaps everywhere. So I really wanted to understand what was going on. Why does the original ERA conflict call into question so many of our conceptual ways of thinking about trends in US history? And another thing to say about the original ERA conflict is individuals that we typically cheer as champions of human rights, like Eleanor Roosevelt, she opposed the ERA. And people like Frances Perkins, the first woman Secretary of Labor, and she's typically cast as a hero of women's history. She also opposed the ERA. So it just begs this question of, well, what's really going on? What is motivating people to be opposed to it or to support it? So I really wanted to figure out what the dividing line was.
Oh, good. And we're going to talk about some of those, what those dividing lines were and sort of the strange bedfellows that kind of came together for it or against it. But I just want to also set the scene on what life was like for women after the passage of the 19th Amendment in 1920. How, of course, they now then had the right to vote, but little else in terms of rights. And of course, we know women of color really didn't even have the right to vote. So tell us what life was like in terms of rights for women after suffrage.
Okay, so that's a great question. And before I get into life after the 19th Amendment and the ways in which the 19th Amendment served as a springboard for the original ERA conflict, I just want to say the main argument of my book so people kind of understand how I'm getting at it. So the main argument is that the original ERA conflict created gendered citizenship in the United States. So even though the 19th Amendment disrupted the traditional understanding of US citizenship that had given men authority over women in law and in custom, disparities between men and women's positions persisted because ERA opponents in the original ERA conflict modernized or updated the justification for sex-specific treatment in the original ERA conflict. So to unpack that a little bit, to get at your question about what women were facing after the 19th Amendment, it's important to recognize that the U.S. legal system was founded on a profound commitment to the maleness of rights-bearing citizenship. U.S. legal and political authorities understood white women, and then after the Civil War, Black women, to be citizens and that they were inhabitants of the country. But when it came to being a full citizen or a citizen who enjoyed all the rights of citizenship, United States laws and customs denied women that status of rights-bearing citizenship because U.S. legal and political authorities believed that all women were inherently dependent, weak creatures who relied on others, especially men, for survival. So I'm not going to go fully into all that legal history. If anyone's curious, I really dive into it in the first chapter of my book. but it's important to understand that the original masculine conception of full U.S. citizenship gave men authority over women in law and in custom. And it's also important to understand that the category of sex was commonly used as a valid reason to restrict women's opportunities and autonomy in the home and in public life. So before and after the 19th Amendment, there were an array of sex-specific laws and policies that denied or limited women's right to hold public office, serve on juries, work in certain occupations, even have an independent nationality status. And there were also an array of sex-based laws and customs that continued to favor husbands and fathers over wives and daughters with regard to property, earnings, contracting, inheritance, and guardianship rights. So when the 19th Amendment was passed in 1920, what it did is it removed sex as a valid reason for withholding the right to vote. So for those that don't know, the actual language of the 19th Amendment, and I'm going to try to say it off the top of my head here, was something along the lines of the right of a U.S. citizen to vote cannot be abridged or denied on account of sex. And the implicit suggestion with that wording is that it affirmed women's right to vote. But because it removed sex as a valid reason for restricting the right to vote, it raised all these other questions about, okay, well, can sex be a valid reason still for limiting and restricting all these other rights, like the right to serve on juries and hold public office? So a lot of debates and questions arose in the wake of the 19th Amendment regarding women's legal status going forward. A lot of debates concerned, okay, well, what were the constitutional ramifications and effects of the 19th Amendment? Were there implications beyond the vote? Do women have broader political rights now? And underlining all these questions were, well, what are the rights of citizenship after all? Should women still be held to a different legal status, or should they be held to the same status as men now going forward? And something I kind of touch upon in the piece that I wrote for Gender on the Ballot was about how some of these arguments played out regard to women's right to hold public office. Even after the 19th Amendment, there were still restrictions on women's right to hold public office. So the concerns and the debates about the transformative possibilities of the 19th Amendment, played out in the political discourse of the early 1920s and in several court cases. And for the purpose of my book, what you see is those debates over what the 19th Amendment meant evolved into the original conflict over the Equal Rights Amendment as two different interpretations of the principles of U.S. citizenship developed. So if you want, I can touch upon how this brings in Alice Paul.
Yeah, because I was going to ask you about her. I mean, obviously, we had spent the whole 2020, right, talking about the suffrage centennial, talking about suffragettes, and I think people familiar with Alice Paul's role in all of that, but she plays a big role in this as well. Tell us more about that.
Okay, so as all these questions are going on about what's women's legal status, what are the nature of rights now that women had their, implicitly had the right to vote, a group of individuals, which Alice Paul was the leader of, decided that an additional constitutional amendment was needed in order to resolve all these issues regarding women's legal status. So I'll just give a little background on Alice Paul, just in case some people aren't familiar. So Alice Paul was an incredibly influential suffrage leader, as you said. Some scholars describe her as representing more of the militant side of the suffrage movement. So she's famous for, she founded the National Women's Party, NWP, and she and her party are famous for picketing the White House for a political cause, the cause of suffrage. They were arrested when they were picketing the White House and jailed, and they did a hunger strike in jail for the cause of suffrage, and then they were force fed. She's also well known for orchestrating and organizing the massive and spectacular suffrage parade in Washington, D.C. in 1913 around President Wilson's inaugural celebration. So Alice Paul was a brilliant strategist for capturing the attention of the press and the overall public to the cause of suffrage. So as all these questions are going on in the wake of the 19th Amendment, Alice Paul and her very good friend, Elsie Hill, another leader of the National Women's Party, got together with a up-and-coming legal scholar by the name of Albert Levitt at the George Washington University. He was already working on trying to secure women's rights in certain areas. They got together in the spring of 1921 to figure out what to do to resolve these issues around women's rights.
Mm-hmm.
And I just want to say at first, so they came to the idea of pursuing an additional constitutional amendment. But at first, this additional constitutional amendment was really more of like a clarifying amendment to really kind of clarify what women's rights should be going forward. So it wasn't at this point embracing the complete constitutional equality that you would see in the ERA later on.
Right.
So Albert Levitt actually wrote the first draft of this clarifying amendment. It was very lengthy, and he literally wrote every single right that they were trying to get for women, like the right to serve on juries, hold public office, have an independent nationality status, things of that nature. And at that point, things really just took off. Alice Paul really wanted this drafting process to be collaborative and a shared effort. So she consciously went out and brought people into the drafting process. So there was an array of individuals involved, which I tried to capture in chapter 2 of my book. Like Roscoe Pound, he wrote up some drafts. Albert Levitt said that he wrote 75 different drafts. Alice Paul wrote a couple hundred different drafts. Let's see who else was involved. Dean Acheson, who would go on to be an influential foreign policy advisor for presidents. He wrote a couple of drafts and gave some advice. Some lawyers within the NWP helped out, people outside the NWP. So it's just a very collaborative effort. And it was really great to go through the sources and see all the different ideas at play. But things started to break down. In the fall of 1921, the collaborative effort kind of fell apart. And it definitely fell apart. So the main reason that it fell apart is because some of the people involved wanted the clarifying amendment to include a provision that would secure what they believed to be women's natural right to special protection. And at this point, Alice Paul wasn't against that idea, but she wasn't for it. She was kind of like on the fence about it all. And when she wouldn't commit to it, and I am like summarizing a very complicated history, which I go way more into detail in my book. But when she wouldn't commit to that saving clause, or this clause to protect women or protect what was believed to be women's natural right to special protection, the individuals committed to that idea said to Alice Paul, "You're on your own. We're not going to help you anymore." And it was actually quite a dramatic and emotional breakdown. Albert Levitt and Alice Paul got a humongous fight with each other because he was one of the people that wanted a saving clause. And it was very distressful for Alice Paul. So at that point, she decided to put the amendment on hold. So this is the winter of 1921. And she launched with the National Women's Party a major investigation into the legal status of women, which really took off in January 1922. And so it's important to understand this massive research project because it really gets to the idea of what were women facing in the early 1920s in terms of legalized sex discrimination. So many of the problematic laws restricting women's autonomy and opportunities were on the state level, and they varied from state to state. So it was a very confusing patchwork of laws. And what Alice Paul was thinking is, okay, let's go and investigate these laws. Let's record them. Let's chronicle them. Let's see if any of them are beneficial for women, or let's see if they're all harmful. And so it's in this massive research project, which really lasted from the 1920s up into the early 1930s. And the NWP wrote several different reports throughout this time. But it was through this process that the NWP became way more critical of the idea of sex-specific treatment and sex-specific laws, and more attached to the idea of complete constitutional sexual equality. And I just want to say some of the things that they found in their reports on the sex-specific laws that were harmful to women. So in some of the reports, they showed that, I think it was in 40 different states, property acquired through the joint effort of husband and wives still primarily belonged to the husband. Several states still had husbands controlling women's earnings. Several states still prohibited women from entering into contracts without their husband's permission. And then, as I've already said, several states restricted women's ability to serve on juries or hold public office, work in certain occupations. Some states, the father had a right to will away the custody of a child from its mother. So there's just a lot of laws that are favoring men and giving men dominance over women. And like I said, through the research into these laws, the NWP became way more attached to the idea that that sex-specific treatment was always going to be problematic for women and was always going to be harmful for women, and that women didn't just need a clarifying amendment. They need an amendment that was going to emancipate them from a legal system that had put them in a subservient position.
Well, and you mentioned emancipate, and you also mentioned special protection, and this is how you kind of divide the pro ERA set and the anti ERA set, if you will. So, give us a sense of those definitions and who's lining up on each side of those arguments. And like I mentioned earlier, there are these strange bedfellows, meaning that you have liberals and conservatives within one wing and liberals and conservatives within another wing.
Yeah, exactly. So, okay, so I'll first dive into emancipationism a little bit. So, and then I'll get into the protectionist side. So emancipationists were ERA supporters. They supported the ERA. And I use the word emancipate or emancipationist and emancipationism to capture the pro-ERA position, because ERA supporters often actually use the exact word emancipate or to emancipate when trying to describe the ERA's purpose. So for ERA supporters, women need to be fully emancipated from their legal subservient position in American society. And they thought that the only way to do that was through a strength of a constitutional amendment that would remove sex as a valid legal category in and of itself. So they would basically attack sex-specific laws and sex-specific policies. And the thinking was that sex could never actually be beneficial for women, sex-specific treatment could never actually be beneficial for women, because such laws always were tied back to these ideas embedded in the American legal tradition that understood women to be inherently weaker and inherently dependent creatures who relied on men and others for survival. And then this reinforced the idea that men should have dominance and control over women, and that women can't have autonomy over their own bodies and their own lives. So for emancipationists, persistent legal restrictions on women's civic autonomy in the wake of suffrage created not only fluctuating definitions of women's legal personhood, but also constitutional inconsistencies with regards to the rights of American citizens. So for emancipationists, constitutional sexual equality was the only way to fully emancipate a class of voters from their legal subjugation. So just to back up a second here, to get back to the history a little bit, as the National Women's Party is conducting this big research project into the variations in women's legal status across the states, eventually Alice Paul came back around to writing the amendment, and she finalized the writing of the amendment in 1923. But before she came to that wording, which I'll say in a second, she originally based some of her early drafts of the amendment on the language of the 13th Amendment. For those that don't know, the 13th Amendment is the amendment that freed enslaved persons after the Civil War. And the reason that Alice Paul did this is because she believed that a lot of the state level marital status laws were a type of involuntary servitude for married women. So a lot of these, I don't want to get too much into the specifics of the legal aspects because it can be confusing, but a lot of these marital status laws were formed around the notion that husbands had a right to the body and the free domestic labor of their wives. So again, from Alice Paul's standpoint, this was a type of involuntary servitude for women. But through the course of the research project, Alice Paul and other NWP members were realizing it wasn't just married women who were suffering from these sex-specific laws and customs, it was all women in general. So that's why she broadened the wording of the ERA to be what it was in 1923, which I have it written down just in case I forget. Okay, so it was men and women shall have equal rights throughout the United States and every place subject to its jurisdiction, and Congress shall have the power to enforce this article by appropriate legislation. So a very broad amendment that, very broad amendment that again embraces this idea of complete constitutional sexual equality for men and women citizens. I just want to say very importantly, because some people don't know this, Alice Paul would reword the amendment once more in 1943 when the ERA was gaining in popularity. A few Congress members suggested to her that it would be good to reword it to align more with the language of the 19th Amendment. So the 1943 rephrasing by Alice Paul is equality of rights under the law should not be denied or abridged by the United States or any state on account of sex. That language is the same language that we have today for the ERA. So the 1943 rephrasing of the ERA is the same language of the ERA in its primary cause from the 70s and up to this day. Okay, so back to emancipationists. Sorry for all the confusion there. So
that's helpful.
All right, so in the 1920s, most emancipationists were members of the National Women's Party. There wasn't that much support for the ERA in the 1920s. Right. That's going to change quite dramatically with the increased support for the ERA in the mid to late 1930s and 1940s. So as support is increasing for the ERA, at that point, the emancipationist position is expanding to include pronounced variations or pronounced branches in regards to its liberal and conservative variations. So in other words,
let me just stop you right there, though, for a second, though, because what's going on in the 1930s that is helping this movement take off?
Okay, so in the 1930s, with the Great Depression, there was an increase in the regulation of working women on the thinking that working women were taking jobs away from men, and men needed jobs more than women because men were providers and women weren't. That's the thinking. So there were certain restrictions and policies to try to push women out of the workforce to open up jobs for men. And so as these restrictions are mounting, you're having more and more working women realize the potential harms embedded in sex-specific labor policies. And so that's when they start to come more and more over to the idea of the ERA and sex and having complete constitutional equality. And then it takes off in World War II, which I can get into that later. That's primarily because of the economic demands of the war brought more women into the workforce.
But then the labor laws come back around too, because then that is also an argument for the protectionist side, right?
Yes, actually, great. Good point. So I'll just say real quick, I feel like I'm skipping ahead, but real quick. In World War II, the sex-specific labor laws were suspended because they needed more women to work to fulfill the economic demands of the war. So then this is undermining the idea that women are inherently incapable of performing the same tasks as men. But back to what I was saying, though, as the emancipationist position is growing in the mid to late 1930s and taking off in the 1940s, you're seeing an expansion with its conservative and liberal variations. So you have conservative emancipationists or conservative ERA supporters, like Senator Edward Burke of Nebraska. And what conservative emancipationists found in the pro-ERA position was arguments that aligned with their support for private enterprise and their criticisms of the government's involvement in the economy. And so they would often frame their arguments for the ERA around notions of a citizen's right to economic self-fulfillment, and that men and women should be able to participate in the marketplace on the same terms. And also there's a little bit, well, I should also say, with conservative emancipationists, they're understanding rights in terms of negative rights. So seeing rights as being a way to shield individuals from government intrusion in their lives. And there's also a little bit of legal formalism playing out in some of these more conservative arguments for the ERA, which is basically the idea that if sex isn't a valid reason to withhold the right to vote, then you can't have sex be a valid reason to withhold other rights, like the right to serve on juries. And their mind, you have to have a consistency in the law.
So we have this, I mean, because you say conservative support for the ERA, most people are, what are you talking about, right? And so it is almost this sort of libertarian component, right? Maybe of
Actually, that's a great point. And some of my students from my ERA class actually pointed that out too. So I think that's a very fair connection to make. But then you're also having liberal emancipationists, so liberal ERA supporters. And they're seeing in the ERA more positive rights. So they're thinking about the ERA in terms of expanding the government's influence and ensuring that the government has a responsibility to protect men workers as well as women workers, and ensuring that the government offers policies that will ensure economic security and social well-being for men and women citizens alike. Now, even with these differences and how they're seeing what the ERA could do if passed, both conservative and liberal emancipationists are still expressing their core support for the ERA in the same terms as men and women should be able to participate as citizens on the same terms, and sex should not be a legitimate legal classification in and of itself, that men and women should have full equality before the law.
Right.
So now there's the other side, the anti-ERA side. Yeah. So it's a little bit more confusing to talk about this side, because I think people have some preconceived notions of certain definitions. Let me just take a sip of water for a second.
Yeah. So there will be, I mean, you'll talk about this, sort of the liberal component of the anti-ERA argument.
Yes, which is,
again, is like, what? Right?
Yeah, a lot of people find it surprising that you have individuals like Eleanor Roosevelt opposing the ERA, and she was very much,
that was fascinating to learn.
Mm-hmm. So she's very much what I call liberal protectionist. So the anti-ERA side, I describe as protectionism or protectionist. And I should just point out, for people who haven't read my book, the way that I'm using the term protectionism in my study, I'm not referring exclusively to advocates of special labor legislation. So for those that don't know, special labor legislation or special labor laws arose in the late 19th and early 20th centuries as a way to regulate women's working conditions and shield women from economic exploitation. So these were sex-specific labor laws that determined the jobs and tasks that women were allowed to perform. It regulated their work hours, prohibited them from working at night in certain instances, sometimes gave them minimum wage laws. But these regulations were really based on the idea that all women were mothers or potential mothers, and women's roles in the home necessitate the extra special oversight of the government.
Right.
So you have liberal-minded ERA opponents who love those labor laws and oppose the ERA as a threat to those labor laws. And you also have conservative-minded individuals who do not like labor laws, but they're still opposing the ERA. So both conservative and liberal protectionists believed that women required special protection. They just differed in where that protection should come from. So for conservative protectionists, women's protection should primarily come from the male head of the household. They thought that government reform efforts, like those special labor laws, undermined husbands' governing authority in the household. Now, liberal protectionists believe that government reform efforts could also serve as effective instruments of protection for women. Even with those differences, though, you still have, like I said before, liberal and conservative protectionists believing that women needed special consideration and special protection because of their roles as mothers and caretakers of the home. So a shared desire to preserve the law's ability to treat men and women differently on account of sex after the passage of the 19th Amendment and in the face of the developing equal rights campaign fueled the protectionist position. So alongside this desire, protectionists believe that while women should be respected as rights-bearing citizens, they didn't want the law to categorically group women's rights with men's rights. So as I describe in my book, protectionists, conservative and liberal protectionists, reasoned that actual sexual fairness meant securing two distinct but equally valued sets of rights for men and women citizens. So a key point here is that the arguments against the ERA didn't simply revolve around the idea that women shouldn't have rights or that they should be denied their rights as full citizens. In actuality, ERA opponents insisted that they were the ones who were protecting women's rights.
Right. Which is why protectionist, the wording of that makes a lot of sense. And that is also what we, not dissimilar from what we see in the arguments against the ERA in the 70s, right?
Exactly. Yes. Yes. So I do, in my epilogue, suggest that it's a little bit more confusing than what I'm going to say right now, but a lot of the arguments that Phyllis Schlafly appealed to in the 1970s were arguments that were put forward in the original ERA conflict. So just one quick thing to note, though, what protectionists were doing is through the course of the original ERA conflict, protectionists moved the argument against equal rights or equal legal treatment away from a pre-19th Amendment emphasis on the reasons to exclude women from certain rights of citizenship towards a post 19th Amendment emphasis on the need to protect and develop a distinct citizenship for women that supposedly came with its own set of rights. And for protectionists, women's special rights include things like being exempted from military service, shielded from the ravages of capitalism, and kept safe in their domestic roles. So again, from the protectionist point of view, it wasn't that women shouldn't have rights, it's that they should have their own set of rights. And so this is how you see the original ERA conflict transforming the nature of American citizenship away from what had been a single gender masculine model into a dual gender model with a separation of rights specific to men and women.
I wanted to ask you, I mean, you mentioned Eleanor Roosevelt, which makes me think of the presidents, right? And so can you talk a little bit about presidential support or opposition to the ERA during that time period with FDR, Truman, Eisenhower, who were back and forth on the amendment, and give a little context as to maybe why?
Yes. Okay. So the FDR administration, with the exception of FDR's second vice president, Henry Wallace, he actually supported the ERA, but pretty much everyone else in the FDR administration did not, because the FDR administration was really full of a lot of liberal protectionists. And again, the thinking for liberal protectionists is that women needed sex-specific labor laws because women had special needs that special treatment would recognize and fulfill. And I just have a great little antidote to add here. When FDR had passed away, Alice Paul supposedly said, the greatest threat to the amendment has now been removed. So that just shows you how intensely opposed to the ERA the FDR administration was. Now, Truman, though, actually came out in support of the ERA when he was a senator, and then he reaffirmed that support when he became president. And a part of that, the significance of that, is it just shows how much the ERA had gained in popularity during the 1940s. But as I talk about, I think it's in chapter 5, he started to back away from the amendment a lot through the course of his presidency. And that's because so many, when the protectionists started to reassert themselves in the post-war era, they really went after Truman and really said to him, if you openly support the ERA, we're going to withdraw our support from you. So when I went to the presidential library, Truman's presidential library, and I went through his some of the related source materials, some of his presidential advisors said something to the effect of, like, it's political dynamite. If either way you throw it, it's going to, set off in your face. So he didn't come out and say he was against it, but he just decided to stop talking about it. So, and then Eisenhower, it's the same kind of thing happened.
That doesn't sound like a politician.
I know. So Eisenhower kind of did a similar thing. So when Eisenhower was elected, ERA supporters thought that would be a great thing for the ERA because they thought that he would align with the emancipationist position. And he came out at a speech in, I think, Madison Square Garden and said, I support the ERA. And so they were all excited about it. But then if you go through his presidential source materials, as I did at his library, you see that, he was saying in private things like, I don't know what the ERA is. So his support for it was pretty lackluster. And again, I think it was his Secretary of Labor was very against the ERA for the same idea of women needing special protection in the industrial realm. And so partly because of his Secretary of Labor, Eisenhower, like Truman, also backed away. He didn't come out and say he was against it. He just, again, decided to be quite quiet about it. So it just shows you how protectionists were really able to reassert their dominance in the post-war period.
Right. And so you, in the book, it's original conflict over the Equal Rights Amendment, 1920 to 1963. Why 1963? What's significant about that time?
Great question. Let me just back up for a second. As I said, in the 1920s, there wasn't very much progress on the ERA.
It's sort of
for various different reasons. And then there was a lot of pro-ERA momentum in the mid to late 1930s, and then really taking off in the 1940s. And then after the war ended, certain societal developments create a ripe environment for protections to reassert themselves. I hope I'm not going too much into detail here, but the post-war readjustment anxiety and the feeling that social stability would only come back if women left their jobs in the workforce and returned home allowed protections to, again, reassert their dominance. So I'm just going to go into a little bit of detail here. The idea that women left the workforce after the war and stayed home is actually kind of a myth. In the immediate post-World War II period, women did leave the workforce, but then they went back to work. So by the late I think it's like 1948, the numbers of women working in the workforce started to increase again quite dramatically, to the point where in the 1950s, the numbers of women working outside the home was higher than that during World War II. And so more women working outside the home is aligning with the emancipationist insistence that women should be free to choose how to participate in life, that women shouldn't just be confined to having primary duties in the home. So that's creating a lingering, what I call like a lingering emancipationist impulse. So the ERA is still floating around. Both political parties endorse it again in 1948, and it's brought to the Senate floor in 1946, 1950, and 1953. Which is really quite annoying to protectionists. So in order to stamp out the ERA, they had to readjust their opposition strategy and stop just being against the ERA, but actually offer up their own alternative comprehensive measures. And with these alternative comprehensive measures, protectionists put forward the idea that the best thing for women would actually be a limited equality, that recognize both men and women as having equal value in their citizenship, but having a separation in rights because of a separation in roles. And so some of these alternative measures were things like the Women's Status Bill, the Hayden Rider. The Equal Pay Act was actually largely an effort by liberal protectionists. And then the biggest one is the President's Commission on the Status of Women. So the President's Commission on the Status of Women released its final report in 1963. So, and that report is such a big deal when it comes to the ERA. So Esther Peterson, the big architect of the PCSW, which is the abbreviation for the President's Commission on the Status of Women, she was an ardent ERA opponent, and she believed that with this commission, they could make the ERA unnecessary and to offer up alternative ways for improving women's status and what she called a more balanced and practical approach towards removing the arbitrary discriminations on women and keeping what she believed to be equitable distinctions in place. And so in the PCSW's final report, it's so important, as I describe in chapter 6, because it's like protections finally came to an answer that they were trying to develop, since the 1920s, basically, which is this idea of how do we get the law to recognize women as full rights-bearing citizens without taking away the law's ability to treat women differently from men. And so what they did in the PCSW is offer up an alternative constitutional approach. And to just summarize it quickly, this alternative constitutional approach basically recommended that interested parties should pursue litigation of a supposedly arbitrary legal sex discrimination with the idea of it going up to the Supreme Court and having the Supreme Court rule that arbitrary sex discrimination against women violated women's rights as citizens under the 14th Amendment. And so the thinking was we could say that the ERA is not needed because women have the 14th Amendment, which will allow the court to draw clearer lines between arbitrary discriminations and supposedly equitable distinctions, so that you would find a limited constitutional equality for men and women citizens.
Great. That was all super helpful. So we've covered sort of the arc, and we have a couple of questions I want to try to get to in our remaining minutes with you here. Let's see. This is an interesting question from AJ, who asks, was there religious support of the ERA?
Religious support for wow, that's a good question. It's easier to say there was religious opposition to the ERA, as you definitely see in the 1970s, opposition from religion. And you see it not to the same extent as the 70s, but you see religious opposition in the original conflict. But support, I had to say, I didn't see it actually clearly in the source materials that I was looking for. That's not to say it wasn't there. It's just not something I saw. But that's a really good question.
Yeah, it's interesting. Here's a question from Sydney, who asked, to what extent has race played a role in the ERA? In your research, did you find any differing levels of support based on race?
Okay, so that's a very good question. And it's not an easy question to answer. And I actually have some notes here to make sure that I can answer it the best to my ability. Okay, so like so many other areas in the original ERA conflict, the role of race you see overlaps and not a clear dividing line. So what I mean by that is you have Black Americans supporting it and opposing it. You have racist ideas permeating the pro-ERA position and the anti-ERA position. And you have support for civil rights legislation and the civil rights movement on both the anti and pro-ERA positions. So just to give a little bit of detail, and I won't go too much into detail here because I know we are shorter on time, but Mary Church Terrell of the National Association of Colored Women, she was a big ERA supporter by the late 1930s, and her organization endorsed the ERA. But Mary McLeod Bethune, who is a well-known civil rights activist during the 1930s and 1940s, she opposed the ERA, and she was more aligned with the liberal protectionist stance. She was a supporter of the Women's Status Bill, which was a protectionist measure to kind of stamp out the ERA. And then you also have racist attitudes, like I said, pervading both the pro and anti positions. So you have someone like Florence Kelley, who was a social reformer and a big ERA opponent, testifying in Congress in the 1920s, saying something to the effect of, if the ERA were to pass, it would mean that Black men and white women would have the same rights. So just a very racially charged argument to try to flare up people's opinions. And then you also have people on the protectionist side, like Esther Peterson and Representative Emanuel Seller, who hated the ERA, but also were very strong supporters of the civil rights movement. And in their mind, racial discriminations were unnatural transgressions against a person. But they thought that sex discrimination could be equitable because they believed that men and women were so different in their social and biological roles in society. And then on the pro-ERA side, you have people like Mary Church Terrell and other individuals like Alma Lutz of the National Women's Party, seen in the ERA it being a part of one large struggle for the equality of all persons. But then you also have on the pro-ERA side, individuals like Representative Howard Smith, who was a segregationist, a white supremacist, a racist, not good person in many ways, supporting the ERA because in his mind, he believed that it would ensure that Black Americans didn't have an advantage over white women. And in his mind, the ERA meant equality for white men and white women. So again, with so many other areas in the original ERA conflict, you just see these blurred lines.
Yeah, sure. Yeah. Okay, so here's a question I'm sure you never get dealing with, what's next, right? So it's a great question though from Isabel. She says, given the recent renewed interest in the ERA, recent congressional hearings, conversations around Virginia being the 38 states to ratify. Of course, we all watched the miniseries Mrs. America. And have learned about that, and then people taking it to the next level here. Do you think she says, do you think that we're in the third conflict?
I'm so glad that she said that, because that's something we talked about in our class. So yes, I do. I do think we're in a third ERA conflict. Because I am a historian, it's a lot easier for me to talk about things that have already happened. I'm much better at analyzing things when the dust has settled, The third ERA conflict is still unfolding. And I am very interested in how certain things are playing out. I will say that, and I say this in my epilogue, you still see protectionist and emancipationist core ideas influencing both the pro and anti-ERA positions. But there are also some developments. I mean, because we have now such a more fluid understanding of gender than what was in the original conflict and even what was in the 1970s. And I'm not sure how that's impacting the struggle. I just know it is, but I haven't come to an opinion yet on exactly how it's impacting it. So I guess, let's wait a couple of years and I'll probably have a better understanding of it once things have settled a little bit. But we're absolutely in a third ERA conflict right now.
Well, along those same lines, Faith is asking what do you think the likelihood is of the ERA being ratified now?
That's a good question. Okay, so I will say that I had written a op-ed in the Washington Post in March 2021, basically kind of addressing that idea of the likelihood for the ERA to pass. So for those that don't know, the ERA has recently gained the 3 state ratifications that it need to have the 38 states that's required for full ratification, but it's not yet ratified yet because of ongoing questions about the deadline and if it is valid or not. I'm not going to get into all the details there with that, but what I said in that Washington Post op-ed is when society goes through major social upheavals like the Great Depression and World War II, it creates a potential for the dominant cultural consensus to align with the ethos of emancipationism. So the great social upheavals that we've all gone through with the COVID-19 pandemic may have given ERA supporters a chance to finally, help push the ERA through to get fully ratified. I'm not sure if that window of opportunity has closed yet or not, but it's quite possible that it's provided the extra push that ERA supporters have needed.
Great. Let's see. I think here's one more question. Has women's growing representation in Congress and in state legislatures over the past century impacted the fate of the NRA?
That's a great question. So do you think it's getting at with more women in Congress, there's more of a likely... I don't know.
There's more likelihood that it would be passed, or maybe you could say that maybe there is seen as less need for it because we are, have more representation. I don't know. I guess either way.
So I will say that in the original ERA conflict, there were a considerable amount of women Congress members who opposed the ERA because of, again, this idea that they thought it was better for women to have their own set of rights and to have sex-specific treatment. So just because you have an increase of women in Congress doesn't necessarily correlate to having an increase in support for the ERA. I think it really has to deal with having a difference in views of what men and women's roles are in society, having a more fluid approach to it or a more traditional approach to it. Sometimes I see floated around the idea of, is the ERA necessary now, with the fact that there are so many more advancements for women. I mean, I definitely believe that there's still a lot of societal barriers against women. But yeah, I have seen people put forward the argument that there's nowhere near the same amount of legal discriminations against women as there was in the original ERA conflict. And that amendment goes after laws, right? I mean, it's a constitutional amendment. So I have seen people say, well, would it really help with the continued disadvantages against women, which are more due to social practices than legalized sex discrimination. But I will say, if I can real quickly, that what I see as the response to that from ERA supporters today is something along the lines of the ERA is still necessary because it would provide a robust break from that legal tradition that had produced so many of those social practices and social inequities against women. So,
and do you think, for example, looking back to the Phyllis Schlafly days, right? One of the big arguments, against the ERA was this issue of military service and women in combat and the draft, et cetera. Is that because we now have, women in the military, has that argument been kind of removed from the picture?
I would say so. Okay. So if you go to the Eagle Forum website, they still actually have this idea that the ERA would force women into combat on the same level as men. So again, it gets back to this protectionist idea that women has special rights, and one of those rights is being exempted from combat duty or military service. But as you said, in recent years, there has been greater movement towards the recognition that women and that there should be a gender equality in terms of civic obligations. So a lot of times civic obligations go hand in hand with rights. And the thinking is to have certain rights, you need to be able to carry out certain obligations. And so I think what you were referring to is in 2013, the Department of Defense officially lifted the ban of women serving in combat positions. And then 2 years later, the Department of Defense removed all gender-based restrictions to make women eligible for every military service role. And then in 2019, I think it was, a federal judge ruled that the only male requirement for the selective service draft system was unconstitutional and sexually discriminatory. It was a declaratory judgment, so it didn't actually produce a court order. So the only male draft is still in place. But again, when we see this greater movement towards gender equality in terms of civic obligations, I believe it does open up a pathway for greater gender equality in terms of rights.
Great. Well, I think we're out of time, but thank you for taking us through this amazing arc and your book. I would encourage everybody to have the opportunity to check it out. So Dr. DeWolf, thank you so much for being with us. And I want to let everyone know we're taking a little Women on Wednesdays break for Thanksgiving, but we are going to be back December 8th, and we hope you'll join us for what will be our final Women on Wednesdays of the semester with Congresswoman Barbara Lee of California and filmmaker Abby Ginsburg, who are going to discuss Abby's new documentary, Barbara Lee Speaking Truth to Power. And if you register for that event, which you can do either on our website or here via Crowdcast, you will get a link to be able to screen that documentary ahead of time. So we hope you will join us for that as well. And again, Rebecca, thank you. And thanks to everybody who's watching. And I hope everyone has a great Thanksgiving.
Thank you.
Okay, take care.
Thank you.